Hello, ladies and gentlemen. Welcome again to Emeka Ogwonye's session discussing the case of Nnamdi Kanu, giving our members and those that follow me an update on the case. And you may wonder what has happened since my earlier presentation today on the case that will justify further update. But yes, indeed, so much is going on in that case, and so many issues are involved. And as I listen to discussions by other lawyers, especially those lawyers that are closely involved in the case, I begin to wonder, or I try to compare my strategies with their own strategies. I begin to look at the counterfactual. I begin to consider possibilities, and I wonder how they are dealing with those possibilities, assuming they're aware of them or assuming they share my assessment of the case. For instance, I think it's almost absolutely certain that the DSS is preparing to file more serious and far-reaching charges against Nnamdi Kanu. All this discussion going on so far has to do with the pre-existing case. The case that stemmed from his arrest in 2015. You know, I am surprised that everybody is focused on those old charges. I don't think that's where the emphasis should be at this time. This is what I would do if I were in the position of Nnamdi's lawyers. I would see Nnamdi as someone arrested based on suspicion and waiting the filing of charges. Normally, under the Constitution and under all other standards in civilized countries, when a person is arrested based on the suspicion that he committed a crime, the police or the prosecutor, the government, is expected to file charges immediately. The essence of filing charges immediately is so that the matter could be transferred to the judiciary, so that the judiciary could make a determination about the person's immediate arrest and detention. In America, it is called detention hearing. It's not a hearing as to the substantive charges, but detention hearing. What are we going to do with this person pending the charge, pending the trial? So, if you see Nnamdi's case from the point of view of a man arrested pending charges, you will be focusing your attention on what charges can the government come up with. What are the likely charges my client would face? So assuming there was an incident and your client is suspected of being involved in that incident and the police swoop in on him and arrest him. They've arrested him, they've not filed charges, you know charges are coming. What do you do as a defense counsel? You begin to anticipate what the charges would be. You begin to push for those charges to be filed, so you would know what to defend against. Because until those charges are filed, you really don't know what you're up against. So now, Nigerian government is playing a very delicate game in Nnamdi's case. They have him in custody, but not on the basis of a pending charge. If you see it from the point of view of a pending charge, then you have to push them to file the charge. But instead, they got him on the basis of outstanding charges. And they are playing a very, very, very delicate game here because he has actually been granted bail on those pending charges. He already spent 1 year, 6 months in custody, remand, on those pending charges. The only reason he got arrested again in relation to those pending charges will be on the basis that he jumped bail. That assumption, that's it. But indeed, the government is using the pending charge as an excuse to hold him for a longer time pending new charges. I don't know if you understand what I'm trying to say. It is, they didn't go to Kenya to bring Nnamdi Kanu because of those pending charges. That's not why they went to Kenya. They went to Kenya because of the suspected him of further activities which have not yet been charged. So the government is in a very, very comfortable position. They're keeping this man, having all the time in the world to prepare charges. So those charges are my concern, really. Yes, it's important for him to come out. But what we're going to do now is, this is how it's going to play out. Assuming this judge says, okay, I order Nnamdi released, I hereby reinstate his bail, they will rearrest him. That's what the DSS wants to do. The DSS wants to have the opportunity to hold back on these pending new charges and use it to counter any effort to get Nnamdi free on the outstanding charges. So it's a very, very strange scenario. If I were the lawyers, I'm going to be focused on these pending charges, because with that, it's their trump card. Because once granted bail, assuming the judge reinstates Nnamdi's bail, assuming the judge says, okay, release him to prison, transfer him to prison, if the court does that, any of those things, the DSS will now land back with these new charges. That is the delicate part. Okay? So, if I were the Nnamdi's lawyers, I'm not going to be focused too much on the outstanding charges. Yes, I want to get him bail. I want to get him bail, get him out on bail, on held grounds, or justify his absence if you can. Justify why he left Nigeria in 2017. If you can justify that, then the judge will be lenient and reinstate bail that had already been granted to him. So, but what did the DSS do? They have a trump card. Now, when I say they have a trump card, don't get me wrong. I'm not saying that the DSS is right. On the contrary, I think they are acting unethically. This is not how to prosecute a case. This is not how to prosecute a case and expect people to think that you are fair and that you are even-handed. No. What the DSS is doing is playing all kind of nasty tricks, and government is not supposed to do that. Governments are not supposed to play dirty in the way they're playing. So, but from what I'm seeing, unless there is a sudden political intervention, playing it by the law, playing it by the Nigerian standards, Nnamdi is not coming out very soon. They will propound on him additional charges endlessly, and using those charges to justify additional investigation, using those charges to justify detention and extraordinary measures and the kind of games we've seen. So that's what you will expect. If you push the DSS now, they should be pushed, but if you're pushing them, you have to understand what you're trying to do. If you push the DSS now, it's not going to result in Nnamdi's freedom. If you push them, which you should do, that's the right thing to do, push them, what's going to do is you force them to file the charges earlier, the new charges earlier. And once they file the new charges earlier, you'll be able to know what you're dealing with. These are the strategies I'm expecting to play out. On the bigger picture, that is beyond what happens in the Nnamdi's case, we are looking at the strategy, Nigerian government strategy overall in dealing with the main issue. And the main issue is the pressure for separation, the rush to separate, the secessionist ideology. The government has to control it. It is a delicate thing, really. It may go beyond law, and that's really what it's all about. The margin of law and politics. The northern part of the country doesn't want to secede. They want one Nigeria. A significant element in the East, represented by IPOB, wants to secede. An element in the West, led by Sunday Igboho, wants to secede. So you have a parallel development in the two regions of Nigeria, the West and the East. So it's not a thing the courts will answer. The court is trying one man, but you've got millions of people out there in the street asking for the same thing. So if I were Nigerian government, I would develop a strategy outside the court. The court victory, judicial victory will not solve the problem at all, even if you convict. In fact, I will tell you that if Nnamdi is convicted and sentenced, that will actually escalate the tension. And the people in the western part of Nigeria, in the case of Sunday Igboho, they are showing greater sensitivity. You are having traditional leaders in the West coming solidly behind Igboho, and you're having a trial going on in Benin Republic, proceeding at a faster pace. In fact, the court is going to give a ruling in Benin Republic. The court is going to give a ruling on Sunday, and the court conducts hearings until 11 p.m. That shows you a totally different attitude to the issue of liberty. The Beninois are taking this matter urgently, seriously. They want to get to the bottom of it. The Nigerian government, on the other hand, is enjoying the fact that somebody is detained without trial, and are prolonging and protracting the trial. That is a big, big mess. So, but looking at all these things, I think that the government of Nigeria is not on a winning path at all. It's not on a winning path, and it has to find a winning path. Thank you so much, ladies and gentlemen. We shall continue these updates. Thank you.